Hi, today we're going to be talking about a very interesting case, the India solar cells case. Now, this is a case wherein a domestic policy aimed at boosting the growth of renewable energy resulted in an international trade dispute before the World Trade Organization. The case before the World Trade Organization, the India Certain Measures Relating to Solar Cells and Solar Modules case, or the solar cells case for short, was a suit filed by the United States against India, wherein the U.S. claimed that the domestic content requirements, or DCR, of the Jawaharlal Nehru National Solar Mission, the JNNSM for short, violated the national treatment provision of the General Agreement Against Tariffs, the GATT, specifically paragraph 4 of Article 3 of the GATT. Now, one of the issues raised in this case was the use of government consumption exceptions, which is provided in paragraph 8A of Article 3 in the General Agreement on Tariffs and Trade, the GATT. In order to understand the dispute in question, you have to understand two things. The first is GATT 1995. This is the General Agreement on Tariffs and Trade that was agreed between over 100 different nations. And the international body that enforces GATT, the World Trade Organization. Now, the World Trade Organization exists as an entity to provide guardrails on the process of international trade, to provide minimum levels of agreement and treatment, to enforce multipolar treaties, and, which is key in this case, to provide a forum for the resolution of trade disputes between nations. And that is wherein this dispute between the US and India was heard. The two principles key to the General Agreement on Tariffs and Trade and the WTO as a whole are the most favored nation principle and the national treatment principle. Now, the most favored nation principle refers to the policy of maintaining equal treatment amongst all other nations. Now, there are a fair number of nuances involved in this and many exceptions that form the basis for bilateral or multipolar agreements. But that's outside the scope of this video. What is relevant to the solar panels case is the national treatment principle. Now, what this means is that once goods enter into a member state, once they have undertaken the import process, they are to be treated exactly the same as goods that are imported from any other country or goods that are produced domestically. In essence, there can't be any discriminatory treatment to goods on the basis of their nation of origin once they are validly in the market. In order to understand the dispute in question, it's important to understand the context in which the Nehru Mission was adopted. Now, India, with a growing and developing population, has a high need for energy. But as the world is weaning off of fossil fuels, both due to cost, the finite nature of the supply, and the problem of global warming, it was clear to those in charge, at this point the Congress government led by Manmohan Singh, that there needed to be a strong level of investment in renewable energy. And one renewable energy that is plentiful in availability when it comes to dry regions like India is the sun. So the Nehru scheme was adopted as a mechanism to boost the development of solar production and the production of technology to help solar plants. Part of this mission was a scheme that intended to boost the production of components for solar plants within India itself. And this subordinate scheme is what constituted the dispute between India and the US. The JNNSM was an initiative by the Manmohan Singh administration that was launched to establish India as a global leader in solar energy by creating the policy conditions for its diffusion across the country as quickly as possible. Now, one of the key components of this was the DCR, which was a requirement that local producers of solar power utilize components that are manufactured in India. In exchange, the government of India would buy the electricity produced through those components at a flat rate over 25 years. So, in essence, if a producer of solar power bought Indian components for their plant, they would get a guaranteed contract at a flat rate for 25 years. Now, based on this policy, the United States brought India before the World Trade Organization, claiming that the DCR violated Article 3 by providing less favorable treatment to imported components than those manufactured in India. Essentially, they claimed that this was a violation of one of the key principles of the World Trade Organization, which was the National Treatment Principle, which held that goods, once validly imported into a country, had to be treated on par with all other goods of the same kind. In response to the US's suit before the World Trade Organization, India offered a number of defenses, but key amongst these was their use of the exception to the National Treatment Principle, the government consumption defense under Section 8. The general consumption defense is one of a number of exceptions to the National Treatment Principle that are provided in paragraph 8, article 3 of the GATT. In essence, this is a series of cases wherein countries are allowed in the treaty to treat different goods differently based on their production. Now, in specific, the general consumption defense reads, quote, "The provisions of this article," essentially the National Treatment Principle, "shall not apply to laws, regulations, or requirements that govern the procurement of governmental agencies of products purchased for governmental purposes and not with a view to commercial resale or with a view to use in the production of goods for commercial sale." So what exactly is this doing? In essence, this paragraph is carving an exception out of that general national treatment obligation. When making their case, the counsel for the U.S. leaned heavily on two prior rulings issued by the World Trade Organization in interpreting Section 8, and these were the Canadian cases. Now, in these cases, Ontario, which is a province of Canada, launched a feed-in tariff program. In essence, it was very similar to the JNNSM that was in question in the solar panels case. Under this program, solar and wind energy producers in Ontario were granted a 20-year commitment to fixed price purchases from the government in exchange for using a notified percentage of domestically produced components. So basically, just like the solar cells in question, in Ontario, producers of solar and wind power were given flat fee contracts in exchange for using a set percentage of domestically produced components. Now, Japan and the EU brought Canada up before the WTO, and Canada argued that this constituted procurement by the government under Article 3, Section 8. And this is because the end use of the final product, which was electricity, was by the government. So why is this relevant? Well, for that, you have to turn back to Article 3, Paragraph 8A, where the defense is specifically for the use of the commodities by the government and not commercially. It's in essence for the government to use and for government agencies to use, but it's not something that'll be available in the market, that'll be available commercially. So Canada's argument was while the components are being purchased and
being sold commercially within the country. The end product, the end purpose of this scheme was to produce something that was going to be used by the government agency, essentially electricity. Unfortunately, the appellate body of the World Trade Organization disagreed. They held that the proper test was the existence of a competitive relationship for the product. In essence, is there a commercial market? Is there the existence of commercial sales for the product in question? And the product in question was the component. And because the components were part of a competitive market, which was how domestic products were being sold and how the products that were being imported were being sold, the protection of Article 8 didn't apply. In essence, the Canada cases narrowed the applicability and the use of the general consumption exception in Article 3, Section 8.
So, with arguments being made on both sides about the applicability of the Canadian cases, how did the WTO ultimately rule? Unfortunately for proponents of solar energy and homegrown components, the case didn't go India's way.
In the solar cells case, the US leaned heavily on the holdings of the Canadian cases and argued that the competitive relationship test that was established in the Canadian cases, whether there is a competitive market for the goods being discriminated against, should hold and simply dispose of the case. Against this, India attempted to argue that the Canadian cases were not a one-size-fits-all determiner of what constitutes a valid exercise of this exception, that the competitive relationship test was not intended to be read broadly across all uses. And they attempted to distinguish the facts by arguing that the components constituted an input to the production of solar power, and the holding of the Canadian cases specifically stated that they weren't going to make a determination as to the general applicability of the competitive relationship test to all cases wherein inputs were being discriminated against and outputs were being used by the government. However, the appellate board held that whether or not the appellate board previously intended to state a broad rule that would cover all cases, the use of the facts, the schemes in comparison, both the Ontario scheme and the JNNSM, were functionally identical.
So what does this mean? Well, in a very basic sense, it means that despite the initial court's reservations, the exception for government use was going to be construed as narrowly as it was in the Canadian cases. In essence, the government can discriminate between homegrown products only when those specific products are being used by the government, and any upstream components or materials are going to have to exist within a competitive market if they already existed in a competitive market. So if you're importing components for commercial use, that means that those components, no matter what their end use will be, no matter what ultimately product they develop into, those will be subject to the national treatment principle. Now, again, it does have to be kept in mind that this is an incredibly under-examined area of the GATT. There are only a handful of cases, the most prominent of which are this solar cells case and the Canadian cases. So it may be a little premature to have an exact understanding of how far this will be extended, but it seems that through both of these cases, the WTO has signaled that this government use exception is going to be fairly narrowly construed. However, On the flip side, India's Nehru Mission to improve solar use and the development of solar plants in India was not hampered too badly by this case, and work in the mission continues to this day. Thank you for watching. If you like this video, please like, comment with your thoughts, share it with friends and family, and subscribe to see more content.